Hello, everyone. Good morning, good afternoon, and today we have another topic of podcast. The idea of this is how we can give more important to cross-border M&A deal through legal perspective. So we selected the topic dealing with legal challenges in cross-border M&A transaction. Today we have David Edgar. So David is one of the partner in M&A security and governance for Kellen Gates. And we are here to talk about everything in M&A, pre-deal, post-deal. So welcome you, David. Happy to have you here today. And if you
Thank
can
you.
introduce to our audience.
Hi, yeah, absolutely. I'm David Edgar. I'm a corporate M&A partner with the global law firm K&L Gates, and mostly my practice involves cross-border M&A transactions, both public companies and also private companies. And as we talked about before we started today, it really is one of the more complex transactions that companies can engage in, and fraught with risk, but also a lot of opportunity. So it's a practice area that that I really love and enjoy, and gives you the opportunity to always be looking at new things and learning new things, and also tackling some of the more complicated challenges that you run into when you're doing cross-border M&A.
Yeah, thanks, Dev, for your introduction. So when I was very new to M&A, and I remember I used to think that what legal guy will do during the deal process, and I knew that they have a role to play, but I was not sure what is the overall responsibility, how they will drive things, because legal means I thought that would be basic documents and contracts and other things. But when I went inside the M&A team and I started working, I realized the value of legal M&A. So a couple of questions I have, and I have just got some of the inputs from different people about your podcast. And I have my question to you: what are some of the key responsibility of the legal team in pre-deal and post-deal period?
Well, especially in the pre-deal phase, I tend to think, at least my approach is, one of the key factors on the legal team is driving a deal. It may not sound purely legal, but as you know, with many deals that you've done, there's so many moving parts and different functional areas, both internal with the target or the acquirer, and also advisors, that keeping all of those moving parts kind of moving in the same direction toward the same goal in an efficient and quick process, I think often falls, at least on the US side, on the legal team, because I think generally the lawyers will at least touch on most of the diligence streams that are being worked on, most of the integration efforts or objectives you'll touch on. And so, at least from my perspective and the way I try to run a deal, I really want to be very involved in the overall strategic goals. What are the value drivers behind the transaction? Have a good understanding of those, and then really help to coordinate all the different functional areas and make sure that we are hitting timelines, doing things efficiently, and and ultimately creating a legal framework that captures value and hopefully leads to a successful transaction.
Yeah, so I think and that's what I was saying. When we look at pre-deal and post-deal, both are equally important, right? And pre-deal is more important. So it is evident that pre-deal responsibilities are more critical, especially until you have signed and closed the deal. What are your key advice for legal M&A team?
On the legal M&A side, yeah, to me, when you're doing cross-border deals, these days, it's really becoming very complex, because there is this overlay of sort of the traditional deal structures, valuation, financial side, but then what we're seeing in cross-border deals, whether they're coming into the US or, as I do probably in half of the deals, a US company looking to, diversify geographically. There are so many cultural, political, regulatory challenges that we're seeing in deals. So to me, one of the key things is what I know you also like to do, and that's really getting an early start. As soon as you're thinking about a potential cross-border deal, I think it's really critical to have that core team together, which includes legal, to kind of map out, where might we have some challenges in terms of timing or approvals, and start thinking about those things really, really early. Because if you don't, and you sort of wait until you're more reactive, it's very difficult to keep a deal on a timeline, and you may jeopardize the success of the deal altogether if you don't.
Yeah. Also, as you said that, so it comes to my mind, what are the most common legal issues that, arises in a small size deal versus large or maybe complex deals which are more cross-border? So there is any common legal issue that arise due to this a small deal versus bigger deal, local deal versus cross-border deals?
Well, definitely there are significant differences, I think, between, a purely US deal, let's say, where you have a US buyer and a US seller. That's going to go along a pretty well-defined track in terms of thinking about how do we structure the deal, how do we value and finance the transaction, and what are some of the legal risks. You also don't run into any of the maybe difficult choice of law issues that you might find in cross-border deals, where there may be a lot of negotiation around remedies, what courts or what type of arbitration you may use if there are disputes. So cross-border deals bring a whole range of other considerations. I think in the last 4 or 5 years, the most critical, though, are the really much tighter, much more restrictive competition rules that you're seeing around the world. We're seeing that in the US for sure, but you're also seeing that in the UK and Germany and elsewhere around the world. And then the big one for me that I've seen, good and bad, and have been on the side where some advanced preparation has been really helpful, or seen where maybe not thinking through these issues is very complex, are the national security issues. On the US side, that's the CFIUS regime that we have, which governs approvals at the national security level for transactions. But you're seeing CFIUS-like regimes in the UK and elsewhere around the world, and it's injecting a lot of uncertainty into deal timelines and into deal process and risk management around deals.
Mm-hmm. Yeah. So when you talk about legal due diligence, and if you think that comprehensive DD might help you for better deal outcome, like success of the deal, how you think about this statement? Like, if you do better or comprehensive due diligence, the outcome of the deal will be better. So you see this correlation between these two?
Absolutely. And in fact, and you've seen this yourself, if the more experience, what I often say is sort of reps, like when you're working out, the more reps that you've done as an acquirer, the more sophisticated your sense about where traps may be, where there are opportunities that maybe you didn't see in the beginning of the transaction, and where you might have risks that you want to mitigate or avoid. So just doing a lot of deals and learning through that process helps your team, helps your advisors. And I find that, companies that are very experienced in cross-border deals tend to do them, much better than companies that are just trying that, for the first time. But diligence, you're right, is, to me, it's absolutely critical. And we saw the way the deal market was moving, especially up until 2021, 2022, the remedies that buyers had after closing were really, really limited. In some cases, non-existent. That's how strong the seller's market had developed. So if you are missing important embedded risks that are not factored into your valuation model or into the pre-signing negotiation process, you may be out of luck. There's no substitute that a lawyer can develop after closing to make up for a weak, a poorly designed diligence process up front.
Mhm. Yeah, so I think related to this, one question came to my mind just now. So when you are doing the, pre-DD kind of due diligence, you might have, during cross-border, you might have another law firm who might be doing your local DDs, right? How you make sure that the DD done is fully completed? So suppose you are one who are leading entire legal within the company, and we might have legal firms who are doing, legal DD in respective country. How you make sure that legal DD done by those, legal firm is fully complete?
Yeah. Well, this is, I think, one of the great, benefits of being at a firm like I am at K&L Gates, where we do have, very well thought out and positioned offices around the world, in most of the financial capitals and other places. And I do think that has resonated very well with clients and with the market, because these deals are getting, much more complicated, and having that capacity internally, makes a big difference. I certainly can remember when I started, and we were a much smaller, much less geographically diverse law firm. You're right. I can remember on some transactions where we might have, 8, 9, 10 local law firm partners, that we would need to work with in order to get a deal done. And again, it was almost a full-time, job to just manage all of those different people, and with different cultures, different regulatory requirements, different areas that they're focused on. It's no different really today, although I think with these larger law firms like ours, you tend to have maybe less of those. But my view, again, is that the responsibility falls with me or whoever else is really leading the overall deal team. You have to be able to, make sure that everybody is consistently pursuing the same mission, the same timing. Otherwise, you're right. You may find that, everything else is lined up to get to a signing, but there may be 2 or 3 countries that are important to the deal where maybe you didn't learn about an issue that's coming up, and it can definitely derail a cross-border deal if you're not careful.
Yeah, and that is the reason, most of the time while pre-DD, at least we had a law firm which have offices, cross-border. That way you have, control over the DD process. So my next question, David, is primarily on antitrust. So what is the role of antitrust in whole transaction?
Well, I mentioned that at the beginning. It's I think it's one of the more critical ones. We actually saw, I think just a couple of days ago, I believe June 27th, the Federal Trade Commission and the Department of Justice on the U.S. side, who kind of coordinate and administer our U.S. antitrust laws, they just came out with what I've seen described as very sweeping changes to the HSR pre-merger notification rules. And those are the rules that prescribe when parties to a transaction have to notify the U.S. antitrust authorities. I wrote about it saying, in my view, it wasn't that big of a change, because although it may seem that way, because we've been seeing that for the last couple of years on the U.S. side, much more difficult antitrust process, much more skepticism on the U.S. side about doing remedies. They're more in favor a little bit about just blocking transactions or putting roadblocks in front of transactions that that they don't like. And I think there's also a mixing a little bit of national security and antitrust policy, so that you're using things that were designed just for anti-competitive purposes, perhaps to influence more of an economic or political agenda. And these are very complicated things for lawyers to handle, because we're used to, looking at a law and trying to interpret it. When you're injecting into it political factors or economic factors, it makes deals much more challenging to plan and to execute. And you're seeing that in Europe and elsewhere, much stronger antitrust enforcement, much more focus on things that the antitrust authorities didn't focus on before, like transactions that aren't per se anti-competitive, but that might involve sensitive technology or very large companies that could capture a particular market, even if they're not in the market now. People refer to those as killer acquisitions or names like that. And so you're seeing a much stronger antitrust enforcement, and deal timelines as a result of that are stretching out longer. And so you have to plan for that. That means there's more likely to be intervening events that could set the expectations of the parties off from where they were when they signed the deal. So thinking through, how do we exit a deal? What remedies are there if the deal is going sideways or isn't approved, are much more important than perhaps they've been, in past years.
Yeah, I understood. I read this article recently. So if you look at starting from initial M&A phase, when the regulatory approvals, everything are, under process, and until the deal is closed, how do the buyer and seller communicate and exchange information and their status quo? What is some key legal advice you would like to, you give both the side, either you buy side or sell side?
Yeah, well, first you mentioned it at the top, which was how critical it is in deals to integrate effectively, and people that I admire that focus on integration and focus on the post-deal process, where most of people like me exit. We're off in many ways. We're off the stage at that point. We've celebrated, the signing and then the closing, and then we're moving on to another deal, and all the challenges of actually making the project work and make the deal work. Luckily for us, we're off of, and it's handed on to somebody else. But I've heard a statement that day one is too late.
Yeah.
That if you're waiting, and I love that, because if you're thinking that you're waiting until day one, which is the way I always thought of it, and then you start thinking about, how do we make this business grow? How do we make it work? How do we get the people to be happy and satisfied and excited? You've missed it. And so I do think thinking about integration from really day one of the deal planning process, not day one once it closed, is very, very important when you're thinking about deals. And the lawyers have a role to play in that, although I think our role has been viewed more as a gatekeeper, because there are antitrust restrictions and other rules that prevent you from gun jumping, as we refer to it in the US. So you can't start integrating, especially competitive businesses, in certain areas, but you can do a lot of planning, you can do a lot of thinking, you can set up procedures and processes that comply with the law, that allow the parties to start that integration process earlier. And I think that the companies that are good at that, and good at sort of front loading that process, see much better results in their post deal performance.
Right. I remember, the deal where I was involved, at least I know up to 100 days at year one, we have a dedicated legal team working with us. Yeah. And that really gave us lots of confidence, because many times we need this, many things which we identify very early during DD phase. We wanted to be, bring those practices, embed them, and they're part of integration team. So they are not, coming and going after the deal is done. Once the deal is signed and closed, they continue working till integration is fully closed. So I think some of the practices I remember, and I know the value of having legal team till at least year one integration.
Yeah, it's true. And one of the things I'm seeing more of is more thinking through the people aspects of M&A. I've written a lot about that, and even done some LinkedIn lives about that with some great guests who really think about the people drivers, the talent drivers of deals. And I've been thinking about ways that, from the structuring side, how can we create incentives in the valuation, in the purchase price consideration, maybe using contingent consideration or other types of equity awards as a way of capturing more of that value that you have in the people who can walk out the door every day, and so that is a very important part of thinking through the integration part of deals.
Yeah, so I think we spoke about how much legal teams should be involved during post-merger integration phase. So what are some of the top priority of legal you think that during post-merger integration we should have?
Yeah, well, to me, I love the idea of having the legal teams, much more involved in the post-deal integration phase. I do see that with internal counsel, so in-house lawyers that I work with a lot, that are at companies that doing a lot of deals, and I do think keeping those teams integrated. I think some companies still use that model where there is a sort of a corporate development function, and and they're the ones sourcing deals and thinking about deals and putting deals together, and then they vanish. So the people that are making the promises about synergies and efficiencies and targets that we're going to hit, they're gone. The integration people who have the responsibility for actually meeting those goals, then come on the scene. That never goes well, rarely. And I do think that when you're combining the legal function, the integration teams at the earliest stage, and then keeping them, consistent, even if you might have some, personnel shifts in that process, but you keep the leads, you keep that focus, that results in much better outcomes in the integration phase, for sure, than siloing and creating separate teams.
Yeah, so because I can frankly tell you that I have seen both sides, and I have seen some deals where during PMI side, after deal is closed, no legal team have been involved, and I
Right.
have seen the other side where when we are setting up integration team across the stream, we identified who are the leaders who are going to drive, and the legal was always part of that. Within
Mm.
legal also we had different teams. Somebody looking care for IP issues and making sure the IPs are secured. The other party is looking at all the contracts and other things, making sure that things are right. So I have seen both the sides. So I have some idea when when we discussed before our podcast. So maybe you can give some of the do and don'ts for our audience during pre-deal, during deal, and post-deal. If you can give some do and don'ts, which will be kind of a checklist for our audience.
Well, definitely the one we talked about. Do
Yeah.
integrate the teams. Make sure that you've set up a system using technology like you've developed, or other ways that you can keep everyone sort of moving in the same direction, and find ways to share information so that you don't create gaps in that. And the more complex the deal, the more that is. And
Right.
I do think another consideration we talked about is you really need to think through the timelines of deals, regulatory, political considerations, because if you wait too long, and sometimes you still see clients do that, they don't want to incur upfront costs for outside legal advisors or financial advisors until the deal is moved along. But in today's environment, and you mentioned small deals versus large deals before, we talked a bit about that. One of the challenges, I think, is actually small deals are just as complicated in many cases as the biggest deals, but they don't have the resources and the capacity to actually meet those challenges. So I find, for me at least, probably one of the more complex types of deals are these smaller size deals, maybe under $100 million or so, that are that are very complicated.
Yeah.
It may involve multiple countries, right? But you don't have the resources and the capacity that you would do if you were doing $1 billion, transaction. So those become really, quite challenging. And I guess on the don't side, my mind is, don't view legal as sort of an add-on. In my mind, it's a critical component of the deal. And if the lawyers aren't, kept involved as to what's important in this deal, why are we doing it? You'd be shocked how many times lawyers may not even know, why is my client doing this particular deal? What are they trying to achieve? And how do they want to achieve those goals? Once you know those things, you can tailor the diligence much more laser focused and surgical, which not only saves cost, but you make sure you're catching the things that actually matter instead of just checking things off a checklist, that may not be relevant to the particular deal. And then you also make sure that the agreement provisions actually are tailored to the financial factors, the risk factors that you've identified. I've seen many, deals where issues were identified in diligence. People saw those and they recognized that those were areas that should be important, but they never made their way up to the decision makers so that they could weigh in on it. And they never found their way into the agreement. So you could maybe create indemnities for that or other kinds of risk mitigation. So cohesiveness, coordination, communication, those are really, key factors when you're doing a complicated deal.
Yeah. So, one of the complicated deal where I was working, what I saw that since it was a cross-border deals, almost around 20,000 employees are going to join. There are lots of complications. They have almost more than 100 countries operation. And then what was done is legal was identified, once they close the deal, before that we have a local, one guy identified as the legal counsel, but his role was as a global deployment leader. And his job was to make sure that he oversee acquisitions happening, till integration is fully complete, and making sure that everyone, wherever they are working, they are able to accomplish all the risks which are identified during DD phase. They are being tracked and making sure it is completed. If it is 100 days, it should be done in 100 days. And it was very fantastic because that way what happens is, one is team is fully involved. The second was the team know exactly what they are supposed to do. And there is a way to track, because we have a monthly meeting where the global deployment leaders comes along with everyone, and then he present exactly what was done, what are the top risks identified during DD phase, and how it is getting closed, and what are the best practices. People share as soon as they complete a milestone, they used to share their best practices, and that they used to really retain and distribute to the team. That was very helpful exercise, and it really helped us to know exactly how legal works. And as you rightly said, that complexity in a small deal versus big deal. A smaller company have challenge that they don't afford to hire a legal firm to come and do this. Once deal is done, I think they are not going to engage any law firm, right? Because they don't have so much. Versus if you go to the big company, if the process is built, there is a team to do that. I think the best practices you already mentioned, I think I fully agree. This is the way to do it. So I think these are very important point. David, it's good for our audience. So this was my last question to you. I know that we have a lot of more questions, and with your expertise working across border, I know this experience, and some of the advices you have given is very good for our audience. We'll come back again with another session soon. I think
Great.
there are a lot of things. Even I wanted to really discuss on some of the small, company who come from, they wanted to do a small acquisition, or they wanted to be acquired. They have the difficulty that they don't know how to get prepared, right? So how we can do that? So maybe we'll come back with another round where maybe we define these two different categories, and we'll have some session with you. Thanks for
that's
your
great.
time.
No, I loved it. It was great talking with you, Dharmendra. I really enjoyed the conversation, and you're right. The great thing is about M&A deals, when you really enjoy it, right? You could talk forever about it. There's so many different things to learn from and different experiences that people have had. So no, it's great to talk with you and finally be able to do this.
Sure. Thanks for your time, and thank you audience for your attention. We'll come back with another round of episode, having more focus and detailed discussion with David. And if you wanted to, know more about David, please go and visit. I think David, we keep seeing you lots of posts from you and lots of best practices. I think you can use. Thank you once again. And thank you everyone for listening.